How the Election Tribunal struck out Peter Obi's prayer to retain Tinubu as the president of Nigeria. Nigeria remains the most funniest country on earth. So guys, the ruling today shocks everybody. Just listen to some of the scenes at the Election Tribunal.
Which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes that the fine envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, Section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial conviction. Indeed, in considering the offense that can amount to disqualification under Section 1371 of the Constitution, the Supreme Court held in Action Congress versus ANIC as follows. The disqualification in Section 137, subsection 1 clearly involves a deprivation of right and a presumption of guilt for embezzlement or fraud in derogation of the safeguards in Section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. Clearly, imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offenses by an administrative panel of inquiry implies a presumption of guilt, contrary to Section 36, subsection 5 of the Constitution of the Federal Republic of Nigeria 1999, whereas conviction for offenses and imposition of penalties and punishment are matters appertaining exclusively to judicial power. See also the cases of Amici and Anis Omuwaye versus Attorney General of State, Abdul Karim and others versus Shinkafi. A careful perusal of P5 relied upon by the petitioners showed that the case number 193-TV04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank N.A. Exhibit N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personam against the second respondent. In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held in inter alia that Section 17 of the Advance Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture property under Section 17 of the Advance Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Bath Limited versus Federal Republic of Nigeria, Alison Madueke versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137, subsection 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement of oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioner. In particular, RW2 stated as follows in paragraph 46, 47, and 49. 46 say, in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1. No criminal charge was filed against the second respondent. 2. The second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3. The second respondent did not go through a criminal trial. 4. The second respondent was not convicted of any crime or any criminal activity. 5. No sentence of imprisonment was imposed on the second respondent. 6. No sentence of fine was imposed on the second respondent. 7. No form of sentence was imposed on the second respondent. 8. Case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 9A and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonal criminal sentence was imposed on the second respondent. 49. The second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks for the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, the centralized information center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in the United States, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil, and not Section 982, which is criminal, and which the petitioner stated in their petition. He further stated that in the U.S., even a minor traffic infraction will be reported, so that if someone has a criminal record, the general record will show it. He added that a general search was conducted in respect of the second respondent. A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied with the exhibit RA9 and stated as follows, quote, in relation to a letter dated February 3, 2003, reference number SR 3000, IGP SEC, ABJ, volume 24, 289, 87, regarding Governor Bola Ahmed Tinubu, a record check of the Federal Bureau of Investigation, National Crime Information Center, NCIC, was conducted. The results of the checks were negative for any criminal arrest records, warrants for Bola Ahmed Tinubu, EOB 29, date of birth, March 1952. For information of your department, NCIC is a centralized information center that maintains the record of every criminal arrest and conviction within the United States and its territories. Apart from the above, Section 249 of the Evidence Act 2011 has stipulated how previous criminal conviction outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2. A certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America where a crime was alleged to have been committed by the second respondent. It is significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case and not on the weakness of the respondents. Okereke vs. Umahi, Menike vs. PDP, Omushore vs. Rebushola, Ucha and Elechi. The petitioners have evidently failed to establish the allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D of the 1999 Constitution because he was fined the sum of $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine for an offense involving dishonesty or fraud within the contemplation of Section 137 sub D of the 1999 Constitution. As regards whether paragraph E of Section 137(1) will be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision on the principle that by enacting a separate provision for a part of the general class intends that the said part shall not be treated the same with the general class. The Uchuku Nada versus Attorney General Anambra State, Martin Roida and others versus Mejo and Co. Nigeria Limited, as FMBN versus Olo. In both paragraph D and E of Section 137, subsection 1, a sentence for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced. Then it means, in respect of the sentence for offense of dishonesty, the two paragraphs must be read together. That for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used for disqualifying a presidential candidate from contesting the election. It is also a cardinal principle of interpretation of the Constitution that relevant provisions must be read together and not disjointedly. Abegunde and the State House of Assembly. From all the foregoing, it is clear that having regard to the provisions of Section 137 of the Constitution of Federal Republic of Nigeria 1999 as amended and the evidence laid before this court, the second respondent was not disqualified from contesting the presidential election held on 26 February 2023. Consequent issue 1 is hereby resolved against the petitioners and in favor of the respondent. Issue 2 is whether, having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. Then we shall skip the submissions of counsel. Well, the appropriate starting point for the resolution of this issue is to first consider the objection of the first respondent to ground 2 of the petition, which they raised at preliminary stage, but which we deferred to this stage because it touches on the substance of the petition. The first respondent objection is that the petitioners are stopped from relitigating the issue contained in paragraph 2, paragraphs 33 to 79, as well as reliefs 5.1 and 2 of the petition, as is released to electronic transmission and collation of the election results in view of the subsistent judgment of the Federal High Court in suit number FHC ABS CS 1454-2022, Labour Party Independent Electoral Commission, delivered 23rd January 2023. Certified two copies of which they attached to their petition as Exhibit A, and which was later tendered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55 and 74 of the petition and submitted that the facts alleging non-compliance with the Electoral Act, which are set out in paragraph 33 to 79 of the petition, are hinged on the same issue of electronic transmission of results, which was resolved against the second petitioner in the said suit number FHC ABSC 1454-2022, to the effect that there is no mandatory requirement for the first respondent to electronically transmit results of the election. Reliance was placed on Begin and others was Oriare, Oye Roba, and another was Laupa. An examination of petitioner petition and Exhibit X1 shows that in their petition, specifically paragraph 37, 45, and 45, the petitioners have averred as follows. The petitioners aver that at the conclusion of the election and at each polling unit, the presiding officer was mandatorily required to electronically transfer the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent's result viewing portal, RF, in real time. 45. The petitioners aver that apart from the importance of the beavers in the capture of accreditation at polling unit in an election, the beavers is also mandatorily to be used in the process of uploading the information or data imputed into it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of the result, 1. Electronically transmit the result of the polling unit directly to the collation system as described by the first respondent. 2. Use the beavers to upload or a scanned copy of the Form EC8A to the annual result viewing portal, RF, as prescribed by the first respondent. And 3. Take the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area reward collection officer in the company of security agents. The polling agents may accompany the presiding officer to the registration area reward collection center. In Exhibit X1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454-2022 Supra, which the first respondent is contending to constitute estoppel to ground 2 of this petition. The sole question presented for determination in the originating summons is as follows. Whether, having regards to combined effect of sections 47.2, 52, 64, 65, and 62.1 and 2, and other relevant provisions of the Electoral Act 2022, the respondent can still insist on manual collation of results in the forthcoming general election. Upon determination of the above questions, the plaintiff, which is the second petitioner herein, sought for the following reliefs. 1. A declaration that the respondent has no power to opt for manual method other than electronic method provided for by the relevant provisions of the Electoral Act. 2. An order of this honorable court directing / compelling the respondent to comply with the Electoral Act 22 on electronic transmission of results in the forthcoming general election. In its judgment in Exhibit X1, the Federal High Court held as follows. In view of the foregoing, can the act of the defendant in collecting and transferring election results manually in the forthcoming 2023 general election be said to be contrary to the relevant provisions of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited sections where the Commission or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I am finding that by the provision of sections 52 and 65 of the Electoral Act 2022, the correct interpretation of said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results could be transmitted and are so whole. Consequently, this matter is hereby dismissed. Close of court. It is tried law that for a judgment of a court to conclude estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. The Anchorage Leisures Limited and others versus Eco Bank Nigeria Limited. And Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition